Welcome to Trial Lawyer Prep, where you learn how to better connect with clients and juries, gather strategies for improving your cases, and learn how to use focus groups in the process. I'm your host, Elizabeth Larrick, and in this episode, we will talk about the 3-phase focus group strategy you can use in every one of your large cases. We're going to talk about when to run virtual focus groups, a big question that I get constantly. But here's what I see in reality. Lawyers wait until they're 30 days out from trial to even think about doing focus groups. And by then, they've missed so many opportunities for using focus group feedback to improve what they have. So today, I'm going to give you a complete roadmap. When to run focus groups from the moment you're considering a case all the way until trial. Because here's the thing, focus groups aren't just about trial preparation, they're strategic tools you can use at multiple points in your case to build confidence, make better decisions, and ultimately get better results. We're going to break this down into 3 phases. Phase 1, discovery phase. Phase 2, which I would call mediation or settlement phase, and finally phase 3, which is trial. For each of these phases, we are going to talk about what kind of focus groups to do, what you get from those focus groups, and what it builds for you strategically. All right, let's dive in. Now, let's start talking about our 3-phase strategy. Starting with phase number 1, what I would call your discovery phase or building your foundation. This is the first place where you can begin to run focus groups and learn basic assumptions, basic attitudes towards the facts that you have. And you may be thinking, I don't have enough information to even run a focus group. I don't know all the facts. I don't even know what the defenses will be. That is A-okay, because what we want to do is we want to get a good foundation with what jurors think on just the basic set of facts. Because then you can build off of that instead of against it. Typically, there are 2 really great times in the discovery phase for running focus groups. Timing option number 1 is before you even file the lawsuit. Yes, I am serious. If you've got a large case, you know you're going to invest time, you're going to invest money. You want to do it before you even file. Again, this isn't necessarily every single case, but some of our larger, more complex cases where you're not quite sure how jurors are going to react to the basic facts. Now, these are short focus groups, what I would call narrative neutral focus groups. They're maybe 30 minutes, an hour max, and you're just putting out the basic core facts and getting feedback. You're not presenting all the evidence. You're not even advocating. You're just showing basic photographs, giving basic facts, and asking, what do you think happened here? Where is your confusion? Which way are you leaning? Another great place to run a focus group during your discovery phase is after key depositions. This is where you've taken your key depositions, the defendant, the corporate rep, maybe even a supervisor or key eyewitnesses, and the plaintiff, and you've got video testimony that you want to test. You want to know how believable, how credible are each of these players in your case. Does the story make sense? Is anyone testifying and it's confusing? Right? Who may be the weak link in the testimony? So this again would be a very short focus group. Most of the time, you're going to show 5 to 7 minutes of testimony. You're not going to show 20 minutes, 30 minutes of testimony. People don't need that long to give you gut reactions or blink reactions to what they're seeing. So you could get this done in an hour. You could do 2 hours. It depends a little bit about how many different depositions that you have. I want to point out very clearly, we are not talking about experts. Because again, typically in this phase, we may have experts designated, but we don't necessarily have depots taken yet. That will be in our next phase. So again, thinking through our video testimony of key witnesses, not experts. What you get from these focus groups, again, are credibility. Where are the holes in the testimony? Where's the confusion? And people are great at doing these focus groups. They really enjoy judging video depositions and giving their reactions. So again, what do we get from doing focus groups in our first discovery phase? Well, you're going to get blink reactions to the facts. You're going to find what are the attitudes, what are the hidden attitudes and biases towards the characters, towards the facts in your case. And most importantly, you're going to find the hidden weaknesses, the things that maybe you can't see because you're already so passionate about the case. Maybe jurors don't believe your client, right? This is also really helpful if you're getting ready for your client to be deposed, to give their side of the story. Doing a focus group before that and doing a test run and showing them the test run is really helpful for you to be able to then prepare your client for testimony. The other thing is you may learn that the focus group is very sympathetic to the defendant, or there are other things that they find that are strong in the defendant's side of the case. Maybe there's a fact pattern that doesn't make sense to normal people, but maybe you've been living with it, so you don't see it. And what does it build? What do these focus groups build for you? Well, number one, it builds some confidence about going into depositions, into crafting your discovery, and picking themes that you know will be strong for your case. When you know what matters to jurors, you know what questions to ask in deposition. And even sometimes when we have to pursue documents with motions to compel, you know those are things that jurors absolutely want to see. And here's the thing. If you're doing a focus group before you've taken all of your depositions, you can actually use this feedback to shape your deposition strategy and ask better questions or just get straight to the point, right? So that you make really good clips for the jury to see later on. You can get the testimony that you need to address those hidden weaknesses as well. All right, now let's talk about our second phase, which would be our settlement phase or mediation phase. This is where you're going to be really kind of testing your strategy, putting everything together for them to really test it. Now, we're basically kind of a little bit in the middle of your case. So here we would be getting all the way through discovery. You aren't really chasing anything else for discovery. You've got mediation on the horizon. Maybe you haven't taken those expert depots yet, but they're also maybe lingering before, maybe around mediation. And you're kind of coming to this question of, okay, do I have the case value accurate? Do I have my risk assessment accurate? And so the two key timing spots here would be about that 45 to 50 day mark before mediation. Now, we've talked on this podcast about how we can sometimes, as lawyers, get the mediation focus group timing wrong. If you feel strongly about your focus groups because you've run them in the case and you're feeling very good and you're thinking you want clips for mediation, do not forget about episode 142, which is a common misconception we have about how decisions are made for mediation. If you are waiting 30 days before your mediation to prepare and do those focus group clips to take them to mediation, you may be missing out completely on decision makers. So that's why for this episode, I want to talk about the 45 to 50 day mark for doing your focus groups. So then you can really assess how you will use them for mediation. And then you'll be able to approach it either through your mediator or, again, thinking through. But you don't want to make sure you miss that window of decision making before that mediation, and that's episode 142 if you want to catch that. For mediations, for the most part, from what I'm seeing, there are planned very far out. Now, I understand there may be some that get set very quickly by the court, and you don't have those extra days that we were just talking about. That's totally okay, because you can still run a mediation focus group and you yourself be prepared for mediation, although you may not be using those clips. You could use them maybe later on if you needed to. But however, at this point in the case, we should have everything together, fit into that theme that you're wanting, and you know what people are going to say, you know what the defenses are, you know what the theories are, and you can put together your mediation presentation and test it with a focus group. Now, this is probably going to take a little longer because you want to make sure that you have a solid presentation, and then you also have a solid amount of time for them to discuss and give you feedback. So this may be a little longer, maybe an hour and a half, maybe 2 hours, depending on if you're going to work in clips for your mediation presentation. But it's so helpful for this step because you will get ahead of preparation, you will create it, and then you will have run it through the focus group and then be able to make adjustments to your mediation presentation if you need to. I honestly think this is a great place to do a focus group because it, again, really focuses you to sit down and get organized with the information that you have, because there's going to be a lot at this phase, and you want to make sure you're targeting exactly what you need to knock out those defenses in mediation, but also be able to put together your damages model to demonstrate the case value. Another place in this phase for running a focus group would be 90 days before the end of discovery. Now, this one is critical. You could do it 60 days before, but the whole purpose of this focus group is to make sure you have everything that you need before discovery ends. You may have to go fight. That's why 60 days may not be enough for motions to compel, getting the hearing done before discovery closes. And this may be also a longer focus group because you may have a ton of information and you're just kind of running it through to make sure they see all the pieces of the puzzle and nothing is missing for you. What I hate to see are focus groups run right before trial where there are questions that they have that you can't answer because you didn't go after it in discovery. Now, there may be times where you didn't go after it because you know it would never be admissible. That's different than something that may have been admissible. Maybe it's deposing that last police officer or that eyewitness or some other key witness that may be needed for damages. You don't want to miss out on those things if that's what the focus group, that's what the juror wants to hear. So you want to make sure you have that extra time, that 60, 90 days to be able to go after those things, get the depositions if you need them. Again, I can't tell you how many heartbreaks I've seen where lawyers do a focus group before trial, and again, discovery is closed, and the jurors will say things like, oh, well, I want to hear from this person, or I want to hear from that person. And the lawyer's like, well, we didn't even include him on our witness list, so we couldn't even call him at trial if we wanted to. So then we have to think of a different way to get the information in that the jurors wanted to hear. I want you to save yourself that heartbreak and do those focus groups before discovery ends. All right, what you get from these focus groups during the settlement phase. So you get an evaluation of your case themes. You get an evaluation of your damages model, what jurors are thinking are the strong points or weaknesses, what they're willing to award, and you get feedback again on your witness credibility, who they believe, who they don't believe, how well it comes across. This also helps you significantly when you're developing the sequence of your evidence. These are very helpful focus groups for that. Ultimately, what it helps you build is confidence to reject a bad settlement offer or know when you got to take it. That's the other thing too. So it's helpful to get an understanding of where jurors are on your themes, on your witness credibility, and allow you to make kind of that ultimate decision of, do we go to trial or do we settle? And that's exactly why I push lawyers to run focus groups throughout their case, because you're always constantly making that decision. Do I settle or do I go to trial? And you want information early enough so you can still do something about it. Maybe it's build more value, or maybe it's understanding you need to cut your losses and go to the settlement table. If you're sitting on a case right now and you're wondering whether you should go to trial or whether you should settle, reach out to me, because I set up focus groups every single week. They don't have to be long ones. We have 1 hour, 2 hour, 3 hour. We offer a variety of different ways to run those and present those. And if you're curious about what could happen in your case, please reach out to me. My contact will be in the show notes. All right, let's move it into our last and final phase, and that would be trial. So this is where we're getting close to trial. And I know this is where most lawyers are thinking, well, now is when I'm going to invest in a focus group, because we've done everything else. And now we know we're going to go to trial. We're not going to settle. And that's great. Here we are. But if you've been doing focus groups along the way, it's very helpful to build on what you've done instead of having to start from the ground zero. Starting from ground zero means you pretty much have to do a mock jury because you're going to run everything. But if you've been doing focus groups along the way, you can still get things done in a smaller 2 or 3 hour window without having to make such a large investment. So there are 2 places where you would run focus groups in this phase. And one is 60 days before trial, where you are really getting your opening statement put together. We're doing opening statement versus opening statement, and maybe we're adding in some key evidence. But we are testing your theme. We're testing the sequence of evidence and how you're putting it together. Is it persuasive or not? We're getting everything that you've got and getting it down on paper, getting it presented, getting that PowerPoint ready to get those opinions from the jury. The next period in time would be 30 days before trial. So if we've done an opening statement, now we're going to fine tune and run it again, make a couple of different changes to see if making those tweaks helps. Now, at this point, you may not have motions in limine heard, so you're not exactly sure what evidence will come in. That's where, when we gauge these focus groups, we just play it as conservative as possible. In a worst case scenario, the evidence that's going to come in or come out. And I think most lawyers can make pretty good guesses on this. But if not, again, we're looking at the focus group to really focus on the evidence that we know is coming in, and getting that valuable feedback so that you feel really confident in having your opening statement completed, right? That's a huge burden off of you, because after that 30-day mark for trial, things can get a little crazy. We've got motions in limine, we've got last-minute motions, last-minute depositions that need to be taken. If you've got your opening statement completely done, you can rest easy. I know then you can focus on the other things of getting your cross-exam, your directs ready, and maybe even starting a little bit on your closing. Now, there's an optional place where I would suggest running a focus group in this trial phase, and that would be the weekend before trial starts. Now, I know that creates a huge crunch time for most people, but what I love about doing a focus group the day or 2 days before you start trial is you really get to then practice voir dire and run your opening statement and get as comfortable as possible. This is about practice. This is not necessarily about finding things and changing things. It's about making sure you feel really comfortable with the material, how you're going to move your body, what kind of reactions you're going to get from jury selection, and you're going to gain just little bit more confident in that. And it's, again, going to help you as you get in there for those first day jitters. Now, what do you get from this trial phase focus groups? Well, you're getting your final evaluations of your case themes. You're getting an evaluation of your advocacy, your persuasion, your pacing, the sequence of information, and you're helping understand what is the strongest way for me to build this case. What comes first? Primacy. What comes last, right? Recency. And how can I make sure that we're emphasizing the correct points and not causing more confusion? What does this build for you? Obviously, again, we're always building confidence in our case when we know what our weaknesses are, when we know our strongest points, right? Everything will be tested out. You'll know exactly kind of how things work and what doesn't work. And you can really walk into the courtroom knowing what's on your side and then what you need to work on. All right, so let me just bring this all together for you. We have walked through our 3-phase focus group strategy. You can start from beginning all the way until the end to get information. And again, you're going to be one of those lawyers that avoids waiting until 30 days before trial to even think about doing a focus group, because we want you to get the strategic advantage of focus group feedback along the way as a tool to help you make the good decisions. And again, let's just run through it really quick. Phase 1, our discovery phase. So we're running focus groups before we file. We're running them after key depositions. We can even run them after key documents. We're getting our blink reactions. We're fighting hidden attitudes and weaknesses. And we're feeling really confident in how to put the case together. Phase number 2, which is our settlement or mediation phase. This is again where we're looking at creating that mediation presentation. We're running things to make sure we have all the pieces of the puzzle before discovery closes, evaluating themes, our damages model, testing out witness credibility. And then moving into our last phase, which is trial. Doing those groups 60 days out, 30 days out to really validate your case themes, test your advocacy, and feel as strong as you can before going into trial. Each focus group builds on the last one. You're not starting from scratch every time. You're refining, you're validating, and you're even just getting more confidence in your case and how to make decisions in your case. Here's what I want you to do. I want you to look at the cases that you have right now. Where are they in the process? Discovery, mediation, trial prep. Pick one timing spot from this roadmap and commit to doing a focus group there. You don't have to do all 7. You could do 1 or 2, but getting that outside perspective gets you out of the weeds and into a better place to make better decisions and see it the way that the jurors see it. Thank you for listening to Trial Lawyer Prep. Until next time, keep preparing to win.